Okay, this is WMU Political Science Class 3250 with Distance Learning number 8, our discussion about double jeopardy. If you look at your syllabus, it would be April the 8th, 2020. Chapter 9, sections 9.1 through 9.5, essentially at page 448 of your textbook. I want to spend a few minutes talking about this concept that is commonly referred to as double jeopardy. Stems from the Fifth Amendment. In the Fifth Amendment, among other things that we've already talked about, it says that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. That's where we get the phrase double jeopardy. It's important that we understand what this language means because there's some terms in there that need to be identified, and that includes what the same offense is and what the idea of being placed in jeopardy means. Essentially, layman's terms, double jeopardy is that you can't prosecute somebody a second time for an offense. That is, if you weren't successful the first time, you can't prosecute them again. That's generally what a layperson thinks. But it's interesting to point out that it's not as clear-cut as that may seem. So we'll get to what the requirements are for someone to be able to effectively argue double jeopardy. Before we do so, we should ask the question, why? Why is there a clause in the Fifth Amendment that protects the citizens from this concept of being prosecuted multiple times for the same behavior? The answer to that question is relatively simple. A criminal trial is such a heavy financial and psychological strain on an individual that an accused should be able to move forward and leave the issue behind. If it was always something that they'd have to look over their shoulder for the rest of their life, it'd be something that isn't exactly what we as a society would like to have. We give deference to the defendant. It's a heavy burden on the part of the defendant to have to defend these allegations that the government has one shot at prosecuting them. And if successful, then so be it. If not, then the defendant can move on. This is why we have this concept of double jeopardy. However, in order for double jeopardy to actually be something applicable, there are a number of requirements that have to be met. There's actually 3 main requirements, and we should talk about them so that we clearly understand what the idea of double jeopardy means. First, we need to understand when jeopardy attaches. When do we have the first jeopardy, if you will? The easiest way to say this is that jeopardy does not attach until the trial begins. So if you're prosecuted for an offense of larceny in a building, once you're charged, your pretrial, your preliminary examination, your motion hearings, jeopardy has not attached until the trial begins. When it's a jury trial, jeopardy attaches once the jury is sworn in to hear the case. So after we've gone through the voir dire process, we've picked the 12 jurors to hear this felony. Once the judge swears the jury in to hear the case, then that's when jeopardy attaches. If it's a non-jury trial, it's when the judge swears in the first witness to testify. So up until that point in time, from an investigation to an arrest to a charge, through all those things that we've talked about, arraignment, bond hearing, all those things, if the government chose to dismiss the case or the court dismissed the case for whatever reason, the government could still retry or recharge that individual because double jeopardy doesn't apply because jeopardy has not yet attached. Jeopardy attaches once the trial begins, and it's important to understand that. So you ask the question, well, what protects you against facing criminal prosecution for the rest of your life, but not ever going to trial? The answer to that are the statute of limitations that we talked about, as well as the speedy trial issue. Remember, anytime somebody has been charged with a crime for that period of time while it's charged, they have a speedy trial right. That's when the Sixth Amendment kicks in. So if the government were to charge you, spend a few months working on the case, then dismiss it, then charge you again, spend a few months working on the case, dismiss it, and then charge you again, all of that period of time would add into the equation of whether or not a speedy trial right was violated. So you do have some protection. Short of the trial beginning, you just don't have double jeopardy protection. Important to understand that distinction. In order for double jeopardy to occur, we need to understand when jeopardy first attaches. Jeopardy attaches when the trial begins. So that's number 1. understanding when we have jeopardy. The second thing we need to understand is that the double jeopardy rule only applies to the same governmental unit. So, if the state prosecutor charges you with larceny in a building and they go to trial and you're found not guilty, the state prosecutor cannot prosecute you for larceny in a building again. Why? Because double jeopardy attached, and this would be double jeopardy, and we're talking about the same governmental unit. However, if the federal prosecutor wanted to charge you with that same behavior, larceny in a building, if it happened to be a federal crime, even though you were found not guilty by the state court, federal court could still have jurisdiction over your case and you may still have to defend it. Now, practically speaking, does this happen very often? No. Why? Because the federal prosecutor would defer to the state prosecutor and vice versa. Sometimes the state prosecutor defers to the city attorney if it's a local prosecution. Why spend your resources re-prosecuting somebody? But what's important to understand is that it doesn't preclude them a separate governmental unit to prosecuting an individual or individuals, even though they've already been found not guilty at an earlier trial with a different governmental unit. The case of Rodney King, which is back in 1992, that involved a number of police officers, is an example where double jeopardy didn't apply. A number of officers were accused of and charged with and went to trial for having beaten Rodney King. It was all on videotape. That's why it became so sensational, because it was all filmed. They were found not guilty by the state court. Federal court came in. Federal prosecutor charged them with the same behavior. Why did double jeopardy not apply? Because we're talking about a different governmental unit. The book speaks about a couple of cases. Heath versus Alabama. That was a case where an individual was prosecuted in the state of Georgia for a murder, and he was prosecuted in the state of Alabama for planning the murder. Two separate convictions, not double jeopardy. Why? Because they were different governmental units, one state and another state. Sometimes we see this at a local level because it's a state crime to operate a motor vehicle while drunk. It's also a city crime to operate a motor vehicle while drunk. So if you go out tonight, get drunk, drive an automobile, city police officer pulls you over, the city attorney charges you with drunk driving. If you go to trial and are found not guilty, state prosecutor can come in and prosecute you for the same behavior. Why? Because they're a separate governmental unit. So you need to understand when you're looking at a fact pattern, are we talking about the same governmental unit? Even though jeopardy may have attached, if we're talking about a different governmental unit, it will not preclude that second prosecuting unit to go ahead and pursue a case. The book also speaks at page 739 of the case of Puerto Rico versus Sanchez Valle. What happened there was the Supreme Court had to decide whether or not Puerto Rico, that U.S. territory, was the same governmental unit as the federal government. The reason being that Puerto Rico charged somebody with a crime, the person was found not responsible, the federal government wanted to charge him with the same behavior. The Supreme Court stepped in and said, Puerto Rico and the federal territory that it is has the same governmental unit as the United States federal government. And the Supreme Court ruled in 2016 in a 6-2 decision that double jeopardy bars Puerto Rico and the United States from successively prosecuting the same person for the same conduct. That's number two. One is, did jeopardy attach? Two is, are we talking about the same governmental unit? The third thing that you have to look at is whether or not this subsequent trial, that is, the second trial, involves what's known as the same offense. Remember, the language in the Fifth Amendment says no person shall be subject for the same offense to be twice put in jeopardy. And what does that mean? Well, that's broken down into two different definitions. Let's talk about how we treat it in Michigan, which is known as the same transactions test. That is, if during an entire transaction somebody commits multiple crimes, then the government is obligated, that is, the state government is obligated to prosecute them for all of those crimes that occurred within the same transaction. And if they don't, and they go to trial on some but not all, then they can't later go to trial on the other ones. that they didn't try the first time. Let's talk about an example. Tonight you go out drinking, you get behind the wheel of a car, police officer pulls you over, and you're investigated for drunk driving, as well as having an open intoxicants in the motor vehicle and a bag of heroin in the vehicle. All three of which are state crimes. All occur at the same time. If the government chose to prosecute you for drunk driving and just charged you with drunk driving, and you went to trial, you were found not guilty at trial, can they then later charge you with open intoxicants and or possession of heroin? The answer is no. Why can't they? Because all of those crimes, the drunk driving, the possession of alcohol while in a motor vehicle, open, as well as possession of heroin, all occur within the same transaction. And if you're going to prosecute somebody for one act, you got to prosecute them for all the acts that occur out of that same transaction. And if Jeopardy attaches and you're the same governmental unit, you will be barred under the double jeopardy clause from subsequently prosecuting any of those other behaviors. That's called the same transaction test. Sometimes this gets a bit complicated when you talk about whether or not it is the same transaction. I was involved in a case a number of years ago where a bunch of young men were riding around on various days and knocking over mailboxes and people's property. On Monday, they would go out and hit 5 or 6 mailboxes. A couple days later, they'd do it again, hit 5 or 6, knock them over, and 3 days later, they'd do a few more. The question is, are all of those part of the same transaction, even though they didn't occur on the same day? A court would have to make a decision whether or not that behavior amounts to the same transaction. In other words, can you prosecute them what happened on April the 8th? And then if they're found not guilty, can you turn to the April the 10th incident and prosecute them then? And maybe the April 13th incident. If the court has ruled that the behavior was all part of the same transaction and jeopardy attaches, that same prosecuting unit cannot prosecute for that subsequent behavior if it was part of the same transaction. More often than not, the same transaction is what occurred at the same time. The possession of heroin, the drunk driving, other incidents, the driving with the suspended license, all occurring at the same time. What the federal court uses in some other states is what is known as the same elements test, which is a little bit different than the same transaction test. The same elements test demands that the same prosecuting unit prosecute the same types of crimes from an incident. So, using the example that I just mentioned, drunk driving and possession of heroin. If the federal court wanted to charge you with drunk driving and you were found not guilty, could they later charge you with possession of heroin? And the answer is yes, they could. Why? Because the possession of heroin is not of the same elemental structure as the drunk driving. They are not of the same type. They're separate types of crimes. There's nothing about those crimes that are similar, such that they have the same elemental structure as a crime. So you can prosecute, from a federal perspective, multiple times from one incident if we have different types of crimes. A good way to look at it is the issue of assault. If somebody is charged federally with assault with intent to murder and they were found not guilty, can the federal prosecutor charge that person with assault with intent to do great bodily harm? The answer is no. It's because it's the same elemental structure. And so the prosecution would have to prosecute all the relative assault cases that occurred at the same time together and can wait for the theft offenses or the kidnapping offenses on another day if they wanted. Why? Because those offenses do not fall within the same elements test. Again, know the distinction. Michigan says same transaction. Federal court says the same elements test. Those are the two ways in which we define these terms, same offense, under the Fifth Amendment. So when we look at all three of those things, if we look at a fact pattern, we find all three of those things that have been met, then we have double jeopardy attaching. So let's just use a couple of examples. I'm walking home today. I have in my pocket a bag of heroin. I also have in my pocket I'm carrying a concealed weapon. That is, I got a firearm that I'm not allowed to carry, and I get stopped by a police officer. I'm charged with the carrying a concealed weapon by the state prosecutor, and right before the trial begins, the prosecutor decides, since the police officer who stopped me isn't available, decides to dismiss the case. And then the day after it's dismissed, I'm recharged with the same crime, that is possession of the weapon, as well as I'm charged with the possession of the weapon matter a second time. Has double jeopardy applied? Well, we're talking about the same transaction. We're talking about the same governmental unit, but jeopardy has not attached. So they can prosecute me so long as they haven't violated the statute of limitations and speedy trial rights. Okay? Going back to the start, the hypothetical. They charge me with the possession of the illegal drugs. I go to trial. The jury is sworn in, found not guilty. Can they turn around and charge me with the possession of the handgun? The answer in Michigan is no. Why? Because it's all part of the same transaction. It's the same governmental unit. I carried the weapon, I carried the drugs at the same time. I'm precluded from having to face two trials because of the double jeopardy clause. Same hypothetical, I'm walking down the street, the federal DEA agent stops me. I get charged federally with possession of the illegal drugs. I'm found not guilty at trial. Can the federal court come in and prosecute me now for the carrying concealed weapon? Yes, they can. Why? Because it's not of the same elements. Jeopardy did attach, same governmental unit prosecuting, but I'm not part of the same elements. That is, the crime is not part of the same elements. Okay, same situation. I'm walking down the street. I got the heroin and the firearm in my pocket. I get stopped by a police officer. The state prosecutor charges me with the possession of heroin and charges me also with the carrying concealed weapon because it's the same transaction. I'm found not guilty of both crimes. The federal court then gets my case and I get prosecuted for both crimes in federal court. Same behavior. Double jeopardy apply, jeopardy attached. It's all part of the those two crimes that I was found not guilty of are all part of the same elements. It's the exact same crime, but I can be prosecuted because it's a different governmental unit. That is, the federal prosecutor is prosecuting me now instead of the state prosecutor. So there's all kinds of ways in which prosecuting agencies can pursue subsequent prosecutions. It's important to understand where the limitations are. And again, determining in our fact pattern whether or not there was jeopardy attaching. And again, in a trial, that's when it begins. If there's no trial, we have no jeopardy. We have no double jeopardy then. Jury trial is when the jury is impaneled to hear the case. That is, they're sworn in to hear it. I've had cases where we're picking a jury and the case is dismissed while we're picking a jury. Jeopardy didn't attach because we haven't impaneled the jury to hear the case yet. We're still picking a jury. So in a jury trial, it's when we have the jury sworn in to hear the case, and in a non-jury trial, when the first witness is sworn. The second thing is it must be the same governmental unit. That is it the state of Michigan prosecutor? Is it the federal prosecutor? Is it the state of Alabama prosecutor? Is it the city attorney? Is it the county attorney who's prosecuting? There's lots of governmental units. In order for double jeopardy to apply, we need to be talking about prosecution by the same governmental unit. And finally, it must be a retrial of the same offense, that being the same transaction occurred, the Michigan method, or the same elements test, which is the federal method. That's how we decide whether or not double jeopardy occurs. Is there ever a situation where we have jeopardy attaching, same governmental unit, and we meet either the same elements or same transaction test, and the government can still bring a case that is not in violation of double jeopardy? The answer is yes. Rare, but it is true. And it happens when we have what's known as a mistrial. That is, if the jury is sworn in, they hear the case, the state prosecutor is the prosecutor, and the jury finds the defendant hung. That is, we don't have a verdict. 9 jurors say guilty, 3 say not guilty. We don't have a decision. Can the prosecutor come back and charge them and try the case again? The answer is yes. The rule is that double jeopardy does not apply if, because of the behavior of, if in fact there was a termination of the trial that's not as a result of the government's deliberate causing of the mistrial. In other words, if the prosecutor doesn't cause the mistrial, then they can revisit the case. What if the judge dies after the jury is sworn in? Well, the prosecutor didn't cause the mistrial, so you could retry it again. What if one of the jurors doesn't show up for their jury duty? That's a mistrial. The government, even though jeopardy is attached, even though it's the same governmental unit, even though it's the same transaction, they can revisit the case and try it again. So it's important to understand what double jeopardy needs to have in order to apply, but then also recognize that in those certain circumstances where the court rules that the trial ends and justice would not be served by keeping the prosecutor from retrying the defendant, that double jeopardy takes a back seat. And the examples, again, is a sick or a dead judge, sick or dead jurors, deadlock jury, defense attorney who dies or is ill or is unable to continue while the trial has started. All of those things are not associated with the government's bad behavior. What if the government behaved badly in causing the mistrial? If the government behaved badly, if they somehow inflamed the jury inappropriately or did something wrong because of the government's fault, then they may not be able to bring it. And double jeopardy would again come to life, and a defendant would not be obligated to respond to those charges. So that's, in a nutshell, the concept of double jeopardy. That is, again, jeopardy must attach, same governmental unit, and is it the same transaction or same elements test that has been met? And we don't have one of those unusual situations where we have a deadlock jury or a trial that is somehow ended not as a result of the government's intentional, deliberate bad behavior. All that exists, double jeopardy springs to life, and an accused can understand that they do not have to defend themselves at a second or third or fourth trial. That's the topic of double jeopardy. It's only about 22 and a half minutes or so that I've talked about it. Read up on this. It's important you understand this concept because I can guarantee that on the exam, I'm going to give you one or two examples of the idea of double jeopardy that you're going to need to highlight. Next one will be number 9, and we'll do that starting next week. And then the last one, that is number 10, will be a discussion of the final exam. Thanks.